Hello and welcome back to the IPA's Looking Forward, a weekly podcast of debate and discussion about politics and ideas. Today, if you're an obsessional follower of the news, no doubt your feeds will be full of the death of Ruth Bader Ginsberg, the legendary Supreme Court Justice in the US, and of course the unfolding drama about the appointment of her replacement to that nation's highest court. Today, I'm looking forward. We will, of course, be looking at that, both the constitutional, legal and political issues, but we'll also be asking, why aren't we more interested in Australia about some looming vacancies on our own High Court because of the statutory limitation on how old you can be while you sit on the High Court? There are some vacancies coming up. Why is this not more talked about outside obscure legal journals and Chris Merritt's column in The Australian? Surely we should be more interested in our High Court justices, particularly when they've just come up with a string of interesting decisions, terrible decisions, depending on your perspective. So we'll be talking about that, contrasting the two jurisdictions. Don't forget that Looking Forward is a product of the IPA. If you're not already a member, please do go to ipa.org.au to see how you can join or donate. If you're on an Apple podcast, hit 5 stars now. If you don't like the program, don't worry about the rating so much. To work us through these issues and to make sure we get that 5-star rating, I'm joined first of all by my co-host, Chris Berg from RMIT University. Chris, welcome.
Thank you, Scott.
Great to have you. And, of course, a legal scholar, or a lawyer at least, and a scholar, Andrew Bushnell.
Oh, well, thanks, Scott. I'll try and live up to that billing. Yes. Law school was a long time ago.
Well, I think you get a lifetime permit to
they probably should
opine on
they
legal
should look
matters.
Into that.
Yes, that's right. We don't believe in such qualifications. But we will also be quoting from Morgan Begg, who does actually spend a lot of time in the at the IPA working on such matters. But we are going to start, Chris, with the US situation with the passing of Ruth Bader Ginsberg.
That's right, Scott. So thank you. As you were giving the introduction, actually, I was reminded of a social media post that I saw from the Gosford Anglican Church in New South Wales. Gosford Anglican Church, maybe the most famous woke church in Australia, yes, that put up on its sign the other day, RIP RBG, which, to jump ahead, I think just shows how deeply embedded way too much of our political talking points are in American political issues. But of course, as you mentioned, Ruth Bader Ginsberg passed away at the age of 87 in the last few days. She was appointed to the US Supreme Court in 1993 under the Clinton administration. And of course, in the United States, an appointment to the US Supreme Court is a lifetime position, or at least until you decide to retire. Thus, we are barely 2 months out from the next election, the next presidential election, and Donald Trump has the opportunity, and the Republican Senate has the opportunity to replace a very left-leaning judge with a more conservative judge. Why don't we open with a conversation about Ruth Bader Ginsberg herself, of course, because she's not just any judge on the Supreme Court, Scott, is she? She's almost a cultural icon, particularly on the left, hence my Gosford friends being so keen to discuss that. You've been looking quite a bit into the Ginsberg, not jurisprudence, but reputation. Is that right?
Yeah, it's. I was a little bit ahead of the game, Chris. On episode 74, I reviewed On the Basis of Sex, which was a biopic that was made 2 years ago about Ruth Bader Ginsberg. She does have a reputation that is well deserved. Through her legal advocacy, she was able to drive a series of cases that really changed jurisprudence in America, and then ultimately became a Supreme Court justice. And it's been said that in many ways, when for all those who believe that Supreme Court justices should aspire to some kind of higher ideal and be a little bit above tawdry day-to-day matters, she is probably the Democrats' idea of what that should be, and Scalia was probably that for conservatives. And when you say left-leaning, the point that I made on the podcast 6 weeks ago was that in the context of her times, when she was fighting for women's rights and equality under the law, this was seen as a radical push against conservative actions. By the standards of today's politics, this is almost reactionary. These are not the sort of views that get you invited to speak at Harvard Law School anymore. And so I must admit that I look with some. I share the widespread affection for Ruth Bader Ginsberg as a jurist who certainly came from the liberal, in the US sense, left, but I think does stand for a real honourable tradition in American society of fighting for equality before the law, and using the courts to further that rather than just as opening up the floodgates to whatever progressive cause happens to be the issue of the day.
In that sense, Andrew. Oh, sorry, Andrew, go on.
Oh, I was just going to say on that point, I think one of the interesting themes that's come through amid the eulogies for Ginsberg has been just a slight pushback on her reputation from corners further left, saying that a few years ago in a New York Times profile, Ginsberg said, when asked about why she didn't retire while Obama was president, she said, "If you think that Obama would appoint another judge like me, you're kidding yourself." And people have sort of pondered what she meant by this, but her point seems to be that that she, well, at least viewed from the radical left now, the point there is that she was very much her feminism was more of a liberal feminism. It wasn't this sort of communist feminism, and so there's this kind of little pushback against her, just from the left on this point that she was perhaps too doctrinaire a liberal, and that a number of her decisions ended up siding with America's liberal establishment. She was too friendly with big business and things like this. This is what you hear. And then there's kind of some of her later decisions were more to the left as we understand it now. So I think she was a dissenter in the famous Citizens United case, which found that political spending is a form of free speech. So she dissented from that. And so she sort of became less of a boomer liberal as she got towards the end of her career. But there's this kind of undercurrent of whether her legacy will be, in the future, when we look back 20 years hence, whether she'll be remembered as fondly then as she is now by her core constituency, which is, as I say, essentially boomer liberals.
And she even criticised Roe versus Wade. Tim Andrews, the great libertarian, had something on Facebook this morning with a quote from her saying that Roe versus Wade went too far. She believed the law that was being tested at the time, criminalising abortion in Texas, should have been struck down, but that should have been it. Whereas the Supreme Court in 1973 went out of its way to read into the 14th Amendment of the Constitution a right to privacy. Yeah, so I mean that to say anything other than how enormously good the Roe versus Wade decision is surely heresy from the point of view of the contemporary left.
Well, and I think any decent jurist who serves for such a long period of time will have something of a mixed legacy. The right kind of went through this a few years ago when Antonin Scalia passed away, and he, of course, was famously friends with Ginsberg despite their disagreements, because each of them, lawyers have this kind of thing of recognising brilliance above all others. It's kind of an intellectual...
What do they call it? Associative sorting, basically. You're always friends with someone who's got an IQ within 10 points of you in either direction.
And so they had this sort of mutual admiration society for their intellects. And similarly, Antonin Scalia recommended one of the current justices, Elena Kagan, who's very left-wing, was appointed by Barack Obama. And Scalia, when sounded out for his views by the Obama administration, said, well, you should pick her because she's really smart. Accepting, like, you're going to pick a lefty, so you might as well pick a smart one that I can have some fun with. And so that was kind of the relationship they had. But the right kind of went through this when Scalia passed away, which is, an evaluation of how well his jurisprudence would hold up. In particular with Scalia, he was also like the flag bearer for a particular judicial philosophy, which made him somewhat unusual, which is the philosophy of originalism, which is the idea that the US Constitution should be interpreted in line with the intention of the people who wrote it.
And we will come back to that. We should talk about the politics of it all.
Yeah,
well, no, so let's start on the politics of the current moment, and everything goes so fast, particularly in the United States at the moment, that the current moment is like the politics of this week. So the immediate issue facing the United States right now is should Donald Trump appoint a successor? So we are incredibly close to the election, and the Democrats have pointed to to a precedent that is purportedly or has purportedly been established by the Republicans when Barack Obama was trying to appoint a successor to Antonin Scalia in 2016, again, just before the election, although albeit actually quite a bit before the election in I believe, March 2016. In that case, when Obama was trying to appoint Merrick Garland, the Republican majority Senate refused to hold hearings saying that the next justice should be appointed by the next president, which of course turned out to be Donald Trump. Now, the Democrats are just up in arms about that. They argue that the precedent that was established in 2016 should absolutely hold in 2020, especially because it's even closer. Donald Trump obviously doesn't share that view, as we've seen over the last couple of days. But on that argument, Andrew, why don't I ask you? How do you assess that argument? I mean, is this wild hypocrisy, or is this politics as she's written, or
I think
how do you think about it?
Well, there's two key differences. The first is that we have a Republican. The United States has a. There I go doing it too. The United States has a Republican president and a Republican Senate. So this isn't a case of a conflict between the administration and the Senate, which is what the situation was when Obama had the vacancy in his last year in office. The other key difference, and I think Republicans will lean on this quite heavily rhetorically, is that the treatment of the Democrats in the Senate of the previous Trump nominee, which was Brett Kavanaugh, was disgraceful. And so there's a kind of militancy in this that Republicans will say, what happened with Kavanaugh was a throwback to the attempt to bring down Clarence Thomas when he was nominated by George H.W. Bush. And before that, the failed nomination of Robert Bork under Reagan. And so basically there's a kind of militancy about this among Republicans. And as to the politics of it, that militancy feeds into something, basically that there is no possible compromise here. Having campaigned so heavily on taking control of the courts and taking any opportunity to put their judges on the courts, they can't possibly front up at the election with a vacant seat. They just can't do it. And anyone who thinks that there's a possible deal is just ignoring that very simple fact.
Isn't it just can I just strip it back a bit? Isn't it a problem that politicians and commentators as well tend to dress up their raw political calculations in statements of the most highest of all principles? It is under no circumstances has a Senate ever nominated someone in these circumstances, when in fact all that they were talking about in 2016 is we have control of the Senate and we don't want to. And what the Senate is talking about right now is we have the control of the Senate and we would like to do this, so we will. The only thing that matters here is those votes. And it's not just, I say raw politics, but this is the people who are represented to do certain things.
Yeah, it is politics. It's what they do. And as always, I mean, it was Trump who made subtext text in the best way when he said, well, asked about the difference, he said, well, it's a Mitch McConnell thing. He didn't want to do it in 2016. He wants to do it now. So that's how it is.
But that's also. I mean, all this talk about precedents and rules and things that we project back into the past. At the end of the day, the US Constitution is very clear, which is the president can make nominate someone, and then it's the role of the Senate to assess that nomination, and they either say yes, they say no, or they piss about. Which is, another tactic that they could use. And in this case, delay until after the election creates a range of scenarios that we might consider. But the Constitution is very clear that it is the role of the Senate. So all of these so-called precedents and rules and things are only things that have been tried from time to time. They've never been that hard. And McConnell, clearly in 2016, it was essentially, well, it's like I'm blocking it because I can.
Why, Andrew? Why are we so susceptible to this? So why are we so susceptible? Why do we feel the need to dress these raw political claims about the numbers of people in the Senate up in these matters of high principle? And why do we have to do this? Isn't this is how we've gotten into this situation in the first place?
I think part of it is, psychologically, a need to feel like you're being reasonable. And what that comes down to, if you wanted to be really sort of nakedly utilitarian about it, the game theory is something like we try and dress up our exercises of power when we're in the majority as principled, so that when we're in the minority, we have some kind of moral claim upon you, and you do the same to us, and that's the dynamic, and so, for example, the reason this is even an issue is that whereas previously you required 60 votes in the Senate to confirm, well, you needed 60 votes to end debate about a nominee before it could go to a straight up or down vote. The Democrats got rid of that when they had the majority, and they were told at the time. Mitch McConnell, who's now the Senate Majority Leader, but was at the time the leader of the Republican minority, he said, "You may not, you may look back on this with some regret that you have changed this rule." And so the only reason this is even possible is that the Republicans, who have a 52-48 hold, 53-47 hold on the Senate, can push through, as they did with Brett Kavanaugh. They can push through their nominee with those numbers, and so it's extremely. I would say it's infuriating for the Democrats to turn around now and talk about the norms and precedents and things like this when they changed the rules when it was to their advantage. But it's not just that; it's that it's packaged now with a threat. If you do this, if you fill this vacancy, if we get a majority in the Senate and Joe Biden wins the presidency, we will pack the court. Because it's only a convention that I think you have to change the law, sorry. But it's only a law. It's not constitutional that the US Supreme Court has 9 judges. And periodically it comes up that, well, I'm in quite a strong position, maybe I'll just put more of my judges on there. Famously, FDR threatened to do it to get the New Deal, some of the New Deal legislation approved. As it turned out, they did a deal. It was called the switch in time that saved 9.
It was a threat to the court that worked.
Yeah, and so exactly, and so that's what they're doing now. Is they're threatening the Republicans. They're saying, if you do this, we'll pack the court. Well, where's your norms there, right? So it's obviously hypocritical.
So let's talk about that for a bit, because that's interesting. And a group of never Trumpers have actually been talking about this idea of a sort of a grand bargain that might be cut between the Republicans and Democrats for the next 6 months, I guess, something like that. So the deal would be this, and I'll ask you to comment on it, Andrew, afterwards. The deal would be this. If the Republicans held hearings on the next pick, but right now, but delayed the vote until after the election and we knew who the next president was, then in return for that, the Democrats would agree not to pack the court before the next administration. There's also a couple of other proposals that the Democrats have been tossing around as well that would have some fairly significant implications electorally. So there's a proposal potentially to add Washington, D.C. to give it statehood, which would be clearly a Democratic state. There's a potential to add Puerto Rico as statehood, which may actually be a Republican or Democratic state. But the idea of just cutting a deal, like you won't do this while you have the numbers, and then we won't do this while we have the numbers. What do you think of that? And I'll just say I'm pretty skeptical. But why don't you shake your head?
Well, I think it's naive and it's stupid. Now, it's naive because you are placing your faith in Chuck Schumer, who's the minority leader, he would be the majority leader in this scenario, and he's actually the guy who presided over the changing of the rules that I was just talking about. So it's naive, but it's also stupid, and it's stupid because the Democrats can't lose in that scenario, right? They either get a majority and they can do what they want, or they don't. In which case it's kind of moot, right? Like so you don't appoint one now. They don't. What am I trying to say? That it's stupid because you either the seat stays vacant now and then they get to fill it themselves, the Democrats, or the Republicans win and we just go through this again anyway. I mean, that's the absolute
it's given up
best
a
case.
power you have on the basis of a threat coming from the other side.
Yeah.
I mean, the interesting thing I find about all this is how quickly these have actually been resolved, the politics of this. I mean, there was so in trying to build up this campaign and raise all these questions, the question is always, will there be any senators who actually deviate? Now, there are two senators who have declared, two Republican senators, one from Alaska and the other from somewhere else in America, such as the depth of my research, who have said that they will not vote before the election on a nominee of the president. So they're down from 53 to 51. So they're obviously all this pressure is trying to pile up on other Republican senators. But and yesterday I read Ross Douthat's column, which was basically addressed to Mitt Romney. So, Ross Douthat, never Trumper, New York Times, hates Trump, and he's addressed this column to Mitt Romney saying, look, this has got nothing to do with this. This is the Constitution, straight up and down, do your job. This is what you're elected for. This unites the Republican Party like nothing else. There are no grey areas here for Republicans, and Romney's now come out and he hasn't said he would vote for, hasn't written a black check, but he said if it comes onto the floor of the Senate, I will vote. He has no issue whatsoever with voting on the nominee this side of the election. Yeah. And we are 42 days out and the average is 69 or something, but there have been appointment processes which have been shorter. When I spoke about Ruth Bader Ginsberg on episode 74, I said that window might now be closing, but I don't think it. Hopefully, I didn't say it had closed.
I think it's there's around 2 weeks of Senate sitting.
Yeah,
days,
it can certainly be done.
It can be done.
This is not an unprecedented thing. So yes, it's a bit unseemly, a bit of a rush. But so anyway, the point being, your bellwether, your canary in the cage is Mitt Romney, who I think voted for impeachment. Correct me if I'm wrong.
Yes.
So voted for impeachment, but he said no, I'd vote on this. There's no issue whatsoever.
The other element of that is that unlike any other presidential candidate, Trump issued a list of judges who would be or people who would be considered for nomination to the Supreme Court, and this is a list that's been vetted. These are career lawyers with connections to the Republican Party. It's been vetted all the way, So there's no surprises on this. So if you're like Mitt Romney, it's really not got anything to do with Trump. I mean, Trump will make the final selection, but everyone knows the names involved. For example, one of the leading candidates is apparently a Judge Amy Coney Barrett, and she was appointed by Trump to the federal court only about 2 years ago, and Romney voted for her then. So there wouldn't be any reason, just supposing that Trump nominated her, what would be his objection? It could only be the timing. But he said that that's not a problem. And there's no real reason why, from his perspective, the timing of a presidential election should really factor into his decision as a senator.
Yeah, and that's exactly what he said. I mean, the only remaining political calculus was, my first reaction had been, well, maybe you do the nomination and then you go to the election, and that gives further incentive for swing voters, Republicans, to vote. Because remember, the analysis in the 2016 election was that 10% of those who voted for Trump nominated the looming Supreme Court vacancy there was then a vacancy on foot. 10% of them nominated that as their primary reason for voting for Trump. I mean, this brings out the base like nothing else, and it's actually asymmetric as well. Like, it fires up Republicans in the way it hasn't fired up Democrats, because Democrats took it for granted for so long that that if they couldn't get something through Congress, they could always get it through the court system. And it was only when the Republicans woke up and the Federalist Society, over a multi-decade journey, identified conservative jurists, built up this body of conservative jurisprudence, and ultimately it was Leo from the Federalist Society who provided the first version of the list to Trump. There's been this long process on the Republican side. So, yeah, they've got to do it.
Let's talk about the electoral consequences then, because of course, and we've been talking about this all year, the debate or the contest has really come down until this week to Joe Biden making the argument that Trump has failed on the coronavirus, and by waving a magic Democratic wand, he'd be able to do better on the coronavirus. And Donald Trump has, of course, leaned heavily into a law and order story in response to the law and order challenges around the United States. This suddenly seems to change the trajectory of the election. I don't think we've seen a very large number of polls, or a very useful sample of polls, since the death of Justice Ginsburg. But Andrew, just on the raw politics of this, from the perspective of the presidential election, do you think this helps Trump to try to push it forward now? I do. Sorry, before you answer that, I do have just this nagging doubt that this may not 100% be in Trump's interest to do so. Maybe it would be better for him to hold this, but it's very strongly in Mitch McConnell's, the Senate leader's, interest to push through. How do you see the politics, the raw electoral politics?
Yeah, I think that the argument for not making a nomination would be something like, vote for me to make sure this vacancy is filled in the right way. But I think that's too clever by half. I think you risk. I mean, people would say, "Why am I being blackmailed by a president that I've supported for 4 years? Just make the appointment, mate. Just do it." And
I voted for you to do this last month and a half as well.
This is it. This is actually what I voted for you to do. So I think the electoral calculation for Trump is actually quite straightforward for that reason. I think he can't. There's no downside to him from picking this fight. Do this now. No one's talking about coronavirus. No one's talking about anything else. They talk about this, and it's a promises made, promises kept scenario. You know, Trump said, "I'll be good on the courts. You back me on the courts," and this would be his third pick. It's just a huge cudgel for him going into the election, I think.
It has been interesting though. So on the Republican side, people tend to talk about Roe versus Wade as the key pivotal issue. And they do on the left as well. But the Biden messaging, certainly the Biden messaging that I've seen so far about the Supreme Court pick has all been about Obamacare, which is I think a strategically interesting way to do it. It's trying to pivot a Supreme Court thing back to where he thinks he is strongest, which is on coronavirus. If you vote for Donald Trump again, if his Supreme Court nomination gets through, then we're going to be in a worse healthcare situation than we were already. Which I'm not a American political strategist, and definitely not.
I might throw in there, Andrew, before you pick it up, a scenario that I had painted for me by some different Never Trumpers on the Editors podcast, which is that Biden's worst nightmare, because he's staked out something in the center, in the centre ground, which is his whole strategy. His worst nightmare is that Amy Coney Barrett goes through to the House Judiciary Committee, and Kamala Harris, who is well to the left of Biden, and is who Trump is desperately trying to paint as being the power behind the throne and part of this left-wing cabal that's actually going to pull all the strings on Biden. If her line of questioning is, well, you're a Catholic, is that going to influence your views on abortion? What if Roe? Are you going to try and overturn Roe versus Wade? And the story then is about the abortion fault line in America. It's playing to Harris's base in terms of the sanctity of Roe versus Wade, but it would be bringing up exactly those issues that Biden is terrified of having coming up, and that's where it could really work to Trump's advantage, I think.
I don't think there's that much risk of that, because the Democrats they fold together abortion and healthcare, and so it stays on message. I mean, I think the healthcare angle is actually, or the Obamacare angle is actually pretty clever, because it's kind of a sore point, I think, for Trump, because he is dispositionally in favour of more expansive healthcare. He doesn't have any ideological problem with government healthcare himself. He's made that pretty plain, and yet it's one of the chips that he's continually had to negotiate or pass back and forth with Mitch McConnell, who has a different agenda, which is the repeal side of repeal and replace of Obamacare, which they did partially. So I think it's a pretty interesting angle, because it sort of gets at something that, when I say promises made, promises kept on the court, healthcare is one thing where Trump has not been able to do what he wanted to do, and he keeps making this promise. Even now, he's still saying, we're going to get you a better package, better legislation, and there's been no real movement on that. So I think it's quite clever from Biden, and I think playing up. I mean, I think Harris is probably smart enough to. I mean, there's plenty of other Democrats who can raise the question. I think the last time Barrett was nominated for the federal court, it was Dianne Feinstein from California that asked her about her Catholicism. Famously said, "The dogma lives loudly in you," which is the sort of thing. Which is the sort of thing that you like. It sounds like she thinks that that's a famous quote, or like a regular
from The Exorcist or something.
Like a regular line that you would say. When actually it's just like kind of your own creepy fascinations. But I think it'll probably play out that way anyway, and Harris will get stuck into something else. But I think. I think it's quite a clever line. I mean, for Biden, it's the line here is, I think, very easy. It's we're going to push as hard as we can to knock over this nominee. You can see how high the stakes are with the court. So if you're a left, very radical left winger, and you think I'm too moderate, just remember that. You'd rather have me making these picks than Trump. So it's quite the politics of it's quite straightforward for Biden, because the Democrats don't have the power. Whereas for the Republicans, there's these other calculations. But again, I think, and to go back to the very start of this conversation, I think it's just a naked power struggle, and I think the politics for both parties plays out pretty much straight down the line. If the Republicans can hold together, they only need 50. They only need to hold 50 of their senators, because the tie-breaking vote is the Vice President Mike Pence. So if they can cobble together 50, and you wouldn't bet against Mitch McConnell, then I think that vacancy will be filled.
Yeah. So, Chris, a process in Australia which is absolutely nothing like that at all. There will simply be a media release go out from the office of Christian Porter, the Attorney General, announcing who the replacement High Court judge is.
That's right. It may surprise listeners to know that we also have a High Court, and it also has judges, and they also make decisions. So I might throw to you, Andrew. We've spent the better part of half an hour now on the US system and the fervent and excitable politics around justices in the US. How should we view that from Australia? Because it's very, very different here, isn't it?
Yeah, the key difference is, so they go through this process of the president makes the nomination, and it has to be confirmed by the Senate, and they have these hearings where they ask the nominee about, judicial philosophy and background and all these kinds of things. Whereas our system,
whether they're Catholic or not, things
like that. Important questions like that. Our system takes place basically in chambers. The Attorney General of the Commonwealth Government just makes a selection, and that is what happens. So, and he or she is typically a lawyer, and knows all of the lawyers involved. There's some suggestion that I think it's the most recent pick is Justice Edelman, who's from Western Australia, and he and Christian Porter, the Attorney General, is also from Western Australia, so not exactly unknown to one another.
So Brandis made the pick, but there was...
That's right.
But it was allegedly due to some vigorous support from Christian Porter.
That's right. I've got the story wrong there, the date's wrong, but that's right. And so our process is much more streamlined, and we put a lot more...
Streamlined is such a nice way to describe the administrative state.
And we put a lot of faith in the Attorney General, and basically we do so on the premise that we don't want the High Court to be as political as the United States Supreme Court. And in part, the political nature of the Supreme Court comes down to, the written Constitution of the United States. It's wrapped up in sort of deep philosophical questions, which our Constitution is bereft of, fortunately. And so... and of course, the litigation that they determine in the Supreme Court is about the Bill of Rights, mostly the amendments to the Constitution which grant different rights and how they need to be interpreted. So our process is supposedly less political, and so we put more faith in the idea that judging is a kind of expertise. We just want really clever lawyers to operate essentially as functionaries, making decisions. Our High Court is also different. The US Supreme Court is a constitutional court only. The High Court of Australia is also the highest court in our common law as well. So it'll hear cases on everything, including the criminal law and things like that. So it doesn't only hear constitutional cases. It's slightly different. But the main difference is that our Constitution perhaps is not, or traditionally has not been seen as being invested with such deep philosophical questions that determine the
until they actually until they actually start to make decisions which are invested with.
I'll jump in here, and this is from a great piece that Morgan Begg wrote in the IPA Review, but he quotes Greg Craven making the argument that the system that we have right now, or the system as it is designed, is sort of designed to select against judicial activism. And so while it selects successfully against judicial activism, that's a good, stable equilibrium. But to quote Greg, once it is accepted that the fundamental task of the judge is to mold the law according to his or her policy conceptions, then the case for introducing an element of political accountability for this essentially political task becomes vastly stronger. And I think, Scott and Andrew, over the last couple of years, you could date it back a lot earlier, but really starkly over the last couple of years, we've started to see that the High Court's decisions really can't just be described as that sort of functional utilitarian, you got a job to do judicial work, really, has it been?
Well, the positivist conception of the law as something that's sort of, its meaning is contained within itself, is only possible when there's a widespread consensus about the values that are used to judge the uncertain cases. So this is the famous analysis of the English legal philosopher H.L.A. Hart, who writes about what he called the penumbra of uncertainty, the shadow that's cast across the law in uncertain cases, and this has to be determined in the end by something beyond the law, which is the sort of the moral consensus of the country. And when there's no consensus to appeal to, then these marginal cases become much more contentious, and you want to have, partisans of either side will want to have judges who are sympathetic to their understanding of the values that are going to be used to make these determinations in uncertain cases. And so in Australia, like we've kind of been, we haven't always avoided this, but there has been a consensus, at least among the legal establishment, that has avoided a number of these controversies. It's only sort of now, well, I would say that's probably a bit of an exaggeration, but now is a sort of a moment of increasing politicisation of the court as the courts, the values that it uses in difficult cases seem to have become somewhat detached from the long-run historical expectation of the Australian people. And do you want me to raise the Thoms? That's
the love case.
Yeah,
right?
yeah. Well, just before you do, so I think, and we might before you do. So the over the last couple of decades, probably the first high watermark was the Mabo case, where Tim Fischer, the then Deputy Prime Minister, famously came out afterwards and said that this decision is a reason why we need to get some big C Conservatives onto the High Court, and there was a lot of confusion around that because it was assumed he meant political Conservatives, whereas he actually meant legal Conservatives. But all of that has sort of been lost in the mists of time, and that was probably the last time Australia had a real debate about who gets to be on the High Court and how their legal qualifications should be considered, and whether their status as legal Conservatives or otherwise should lead to them being preferred. And but here we are again with the cases that you're about to talk about.
Yeah, I think Fischer introduced a kind of confusion there, because I think what he really meant was small c Conservative. He meant like in the general sense of the concept as it would apply across various domains. He didn't mean big C as in he didn't mean Conservative as in like loyal to a Conservative party or ideology.
It was almost like by default, whatever judicial activism is, it's the opposite.
Yeah. Not that. Yeah. Conservative towards judicial activism.
And so it raises a heap of interesting questions, that idea of being conservative in the law. And it's come up most recently in this Thoms, the Love Thoms case. There was two cases heard together. One involving a citizen of Papua New Guinea, the other was a citizen of New Zealand, who were convicted of crimes in Queensland, and then they were going to be deported under the Migration Act. The Commonwealth was going to deport them. And what they claimed was that they could not be deported because they had Indigenous Australian heritage. So notwithstanding their lack of Australian citizenship, they could not be aliens under the Constitution of Australia, which gives the Commonwealth power to make laws with respect to nationality and alienage. I think that's the exact wording. No. Anyway, but that's what it is. It's the alien's power. And the precedent on this is quite clear. And in that case, one of the dissenting judgments was by the Chief Justice, Susan Kiefel, and it is just a great. I think we spoke about this on this podcast, but it's a great
at some length.
It is a great piece of legal reasoning. It's 40 paragraphs of extremely tight reasoning that just says the precedent is that the Commonwealth can determine who is an alien. That's it.
It's the plain meaning of the Constitution.
Whereas in this case, the majority, now in classic Australian High Court fashion, the majority decided to issue separate judgments. So all 7 judges in this case decided that their opinions had to be recorded for posterity. But
I feel the same way about my opinions. But
yeah. Well, why are we recording a podcast if not for posterity? But that said, so one of the majority judgments in particular is very interesting on this question of judicial philosophy and what it might mean to be conservative about the law, and that was Justice Edelman. Justice Edelman found that based on the earlier Mabo decision, which had used Indigenous customs and law, traditional law, as a way of indicating property rights for Indigenous people, so that the existence of these customs and traditional laws were held to be evidence of an encumbrance on the land when the Crown purported to take possession of it. And that's where we get native title from. Justice Edelman, in his view, these laws and customs actually speak to a deeper metaphysical connection between Indigenous people and the territory of Australia that the Commonwealth now is sovereign over, such that the Commonwealth's sovereignty itself is encumbered by this connection between Indigenous people and the land. And that is, in short, a political decision. Whether we want to recognise that connection or not is actually a political question based on the prevailing values of the country. And so the argument would be that he has overstepped his bounds as a judge and that this is, in some sense, unconservative. And we would prefer to have a judge who, when a difficult case like this comes up, is much more prepared to defer to Parliament so that the issues can be debated by the representatives of the people, which is the traditional Australian way of resolving difficult political questions. So that would be one sense in which, if we wanted the Attorney General going forward with 2 vacancies coming up in the next 6 months, to appoint a small c conservative, to correct the record, a small c conservative, it would be someone who was prepared to look at the constitutional structure of Australia, in which political questions are determined by the Parliament, and when such a difficult case like this comes up, not attempt to read into the Constitution or successfully read into the Constitution
so in that
value
sense,
questions.
Andrew, and we've had a few conversations about this in the past. The Australian Constitution and the American Constitution are very different, a large part because of what you've described, that there's that ideological content. So it's easy to say in the United States, much easier than here, that to adopt an originalist interpretation of a constitution that is relatively, I'm going to say, libertarian or relatively classical liberal or relatively open markets, conducive towards individual liberty in those sort of in the classical sense. It's one thing to say, well, let's have an originalist interpretation of that, because that is going to pursue that's a conservative interpretation that may pursue conservative ends simultaneously. Now, in Australia, I'm not sure you can do the same thing, can you? Because a originalist interpretation of the Australian Constitution may well imply much greater control of the state, or certainly the Commonwealth Government, over the economy than even has been accepted in recent decades. And I wonder, so to really be clear about this, there's a conservative judge could be one of 2 things. It could be someone who has a conservative theory of law, originalism or what have you, that they read a statute and they have a conservative way that they interpret it. Or a conservative judge could be someone that says, well, given any legal, given any case I have to try, I will take the side that gives me the policy outcomes I want. Not that I have a coherent theory, but I just want to make sure that there are particular policy outcomes that are conservative off the back of them. How do you think about that difference? Do you is this a stark difference that I've made up, or is there a challenge in identifying what conservatism is?
It's certainly not made up. In fact, it's a question that goes to the very heart of what conservatism is. Is it procedural? Is conservatism a way of thinking about how you might approach any given end, or is it substantive in that it's an activity you undertake with a given end in mind? And in the law, this plays out as you say, do we want a judge that applies a particular sort of reasoning, or a judge who will essentially do what it takes to realise an idealised an idealisation of society, which is essentially what, when we say like a left-wing activist judge, is what makes a judge an activist is that the judgments are aimed at realising some kind of ideal society. The American Constitution, as you say, is different from ours in that any American jurisprudence has to reckon with the existence of natural rights as understood by the American tradition. The idea that rights not given to the government, that there are natural rights not given to the government that are reserved to the people. You have to reckon with that, and reckoning with that is actually probably the central question of American conservatism. Is in what sense can conservatism be reconciled with natural rights doctrine at all, is an interesting question. But I think on this particular question, I would say the distinction between sort of procedural and substantive approach is somewhat artificial. I don't think it's made up in the sense of like being completely arbitrary, but it is somewhat artificial in that, naturally just in reasoning, you choose your procedures. There's a dynamic that goes between them. You choose procedures because there are outcomes that you think are better than others, and then you judge your outcomes in part based on the procedure that you took to get to them. So there's kind of there are differences. So I commend to everyone listening or watching Morgan Begg's article, which is now on the IPA website. There'll be links in the show notes. Just search for articles by Morgan Begg. But certainly one of the things he explores there, we spoke about the Federalist Society, whether there's scope for something in Australia, but it is quite different. As you say, we have this different jurisprudence. We do have the wonderful institution called the Samuel Griffith Society. I've got some examples of its the annual volumes of its proceedings there. But our constitution works very differently. We don't actually get the opportunity to know what potential candidates think about the constitution, because it's not something that's determined in lower courts. You can't do what the Federalist Society does in America, which is examine every judgment, or you can perhaps examine law review articles. That's about it. But so the Samuel Griffith Society works in a very different way to the Federalist Society. But I think certainly on the centre right in Australia, there is some interest in saying, well, we must do better than what we did with the appointment of Edelman, who appears to be stupendously smart in exactly the way you were talking about before. But that essentially means that it's like watching a chimpanzee with a loaded revolver. You just got no idea which way he's going to go, and he's there for a very, very long time. Well, the thing about smart people is that their rationalisations are better than others. So
incredibly good.
So they can act on impulse in exactly the same way as anyone else, but then supply reasons after the fact. And I think what we saw, and not just from Edelman, but I think all of the majority judgments in that particular case are examples of that kind of motivated reasoning. They wanted to read something special about Indigenous culture into the Constitution, and they were going to find a way to do it. And ideally, and that's what it really comes down to is a debate about whose values will prevail in marginal cases. Now, I think we would all like, in a way, for there to be not quite so many large, unsettled questions. And fortunately, Australia has perhaps fewer than the United States. We're not quite so riven with these grand philosophical debates, but where they exist, it is a legitimate question for voters. If I vote for this political party, will they not only faithfully represent my values in Parliament, but will their judicial appointments represent my values? And so there is some merit in the way the Americans have gone about it, which is with this nomination process and the hearings and stuff. That didn't happen. That's not constitutional. That's emerged over time as a way to try and manage this deep-seated political conflict. And our system may need to evolve in some way, a way of bringing these disputes to the surface, if it's going to be the case that an ostensibly centre-right government could. I mean, almost all of these judges were appointed by the Liberal Party.
The ones appointed by ALP actually did much better in this case.
Exactly, and so it's a legitimate political question. It's not being rude to ask the question.
And when Christian Porter does make that announcement, Andrew, we look forward to having you back on. Looking forward to evaluate at least post facto.
Yeah, well, I'll throw up an ex post facto rationalisation for my feelings too.
Yes, and we didn't actually get to do the. There are some names floating around out there about who it might be, but we might find another forum to do that. We have come to that part of the program, Chris, where we, I think, probably briefly today, are going to talk about our books and culture picks. What we've been reading, watching, and listening to.
So I've complained about how it's really hard to find time for reading now in our new environment. And I've also mentioned my.
I've got a book.
Board games.
I've got a book. It's a novel, Chris. But anyway,
you're a very bright man.
But you go.
Very literate. So I've been playing board games, as we discussed a couple of weeks ago. The board game I want to talk about today is called Twilight Struggle. It's a board game of the Cold War. It's a two-player game. One person plays the US, one person plays the USSR. It's published in 2005. The idea is to spread influence around the planet to deal with the events, real events that occurred during the Cold War, to dominate certain regions, to win the space race. Based on a series of cards and little influence markers and that sort of thing. It's a fun game, and it's very, very highly rated. But it's interesting in that the mechanics of a lot of these games bring about certain or implement certain assumptions about the way the world works. And this one is really clear, and the designers have admitted that the game is designed as if the entire Cold War was literally someone sitting in DC, someone sitting in Moscow, moving pieces around or moving influence like it was something that you could just buy or sell. Oh, we'll take influence out of Iran and we'll put it into Syria, or what have you. And what's nice about playing with that dynamic is just really recognizing that sometimes we think of the Cold War or even other military conflicts a little bit like that, where you've just got a couple of leaders pushing stuff around a map, and the designers have said that this is an explicit mechanism, and they're aware that the people in those countries that you are pushing influence around, they also had an opinion about this sort of stuff, whether they wanted to be part of the free world or the unfree worlds. The other thing I'll say is also the game's quite good in that it treats nuclear war as a bad option, so the game is lost for all players.
Good note.
If
Good
there's
to know.
a nuclear strike.
I'll note on that. No one cares who's on the Russian Supreme Court. So in terms of influence, one empire definitely prevailed over the other.
That's absolutely right. The Gosford Anglican Church isn't as stacked on that, but it's a great game. It's a lot of fun. It's more fun because you can actually engage with the certain historical moments, and highly recommended for those who are, I hope, going to start adopting my recommendations and get into board games, because they're good now, Scott. I've said this to you before. Board games are good now. They used to be bad. They are now good.
Very good. Well, I might jump in here with my book. It is a novel.
You're going to raise the tone somewhat. I'm going to lower it again, don't worry.
Yeah, no, I have previously on this podcast talked about My Brilliant Friend, the novel by Elena Ferrante about two young girls growing up in Naples. Ferrante is described as the Jane Austen of Italy. They are. It was a splendid book, and but there are 4 books in the trilogy of My Brilliant Friend. It's also being filmed on. It's being shown on Foxtel as well. A series that's being made of it. They've now covered 2 of the books, and I've just finished the 3rd, and working my way through the 4th. So my notional pick is the 3rd novel, Those Who Go and Those Who Stay, because one of the friends stays in Naples, and whereas the other one makes it out, she's able to get a scholarship to a university in Pisa. She then gets published and actually attains some kind of notoriety. She finds a husband who's not from Naples and therefore is one of those rare men in this book who does not beat his wife. And it's sort of this playing out of their separate trajectories and a compare and contrast. It's interesting that some of the bits with the young woman who got away actually bogged down the start of the book. And it's when we return to this maelstrom of Naples and the life of Leela, the much darker and more interesting of the two, that the book takes off again. I do recommend these books again because apart from anything else, apart from being fascinating about Naples, apart from being great novels, I think some of their insights about lives of women in a traditional society coming in through the 70s, the 80s, some insights into Italy and the terrible times it had in the 70s and 80s, what it's like with the mafia in the South and the corruption of politics. All of these things are in there, as well as I think the best use in novel form that I've seen of, I guess, the shattering of the idea of that our egos are a unified whole, that we can speak about in a meaningful way. She really brings out this sense of the different selves that are battling for control of your body at any given time, and the way even other people's desires come in and take over your desires and take over your body. It's sort of there's a bit of postmodern literary theory in there, but it's not done as a theoretical exercise. It's done as a reflection of what's going on in these characters, and all sorts of stuff happens. And so if you're into big novels, Tolstoy, a modern Tolstoyan, Jane Austen kind of thing with like literally dozens of characters doing these amazing things in an historical setting, I can't speak highly enough of My Brilliant Friend, and in this case, the 3rd volume in the series.
Can I also just do a shout out for the soundtrack to the TV show of My Brilliant Friend as well, which is magnificent,
Hans Zimmer?
and I listen to all the time.
Yep, yeah, no, terrific. I think it's Hans Zimmer, isn't it? Yes.
I can't even remember.
Yeah, pretty sure.
Max Richter. No, it's Max Richter.
I beg your pardon. Okay.
Yeah.
Andrew.
Well, another show with a good soundtrack is Yellowstone. Which is
I was going to Google the Yellowstone soundtrack as you talk, if that's okay.
Yeah. The theme music in particular for the song is for the show is really good. And it's one of these shows that's like prestige drama. It's got nice music. I watch it for the landscapes. It's a show about a ranch in Montana and the different threats to it. So it's actually got a really interesting ideological undertone. Kevin Costner plays, he's one of the biggest ranchers in Montana. and he's sort of on either side. He's kind of being pressed by developers who want to take over his incredible piece of real estate and turn it into a resort. And on the other hand, the local tribe, Native American tribe, who used to inhabit the valley and in which this ranch is based, but are now sort of pushed out onto a reservation in the kind of wasteland area nearby. So it's kind of, he's sort of beset by threats from the future and from the past. And that dynamic is actually probably the most promising part of the show. Unfortunately, it's not very well developed. The show takes place in a world that is just simply not like the real world at all. The political machinations that take place. Kevin Costner is this rancher who, and the ranch seems to get bigger or smaller as the plot requires. So it's big enough that he is personal friends with the governor and can install his own son as Attorney General. It's small enough that he might be prey to these developers and outside financial interests. You'd think that those two things don't really go together. But it for me, and the reason I wanted to talk about this is just, why have I been watching this show if I think it's so silly? And it's because it's Montana is called Big Sky Country, and it's and obviously the name Montana is mountains, and it's this beautiful mountainous, wide open landscapes. And if you're feeling trapped at home, as
if you happen to live in Victoria,
if you happen to live in Victoria or any other nascent police state, watching these guys ride around on horses in this beautiful part of the world with so much just open space and freedom is actually very relaxing. Notwithstanding, the show tries to be tense and dial it up, but I mainly watch it for like the montages where they overlay some of this nice music, and I get a rural setting that I can enjoy. And
you just dream of the outdoors.
Yeah, and I just basically dream of the day that I can wander freely.
Yeah, absolutely. Yeah, no, great show. And also the kingdom of woke has not reached as far as Montana. This is
it's interesting. The first,
pretty blokey sort of culture.
The first season is pretty. It does a bit more with that kind of conservative idea that he's kind of got to deal with the past and the future and sort of push on with his business and pass it on to his children and all this. The second season kind of introduces like a bit of a university professor with kind of a woke agenda. It's almost like an apology for the first season being too right wing, but. It's like it's worth watching, but it lives up to the idea of escapism at the moment. It's escapist TV.
When you said that, I just had a rotten feeling that we have actually talked about this on the podcast before. We'll have to go back and check the records. I've got a bit of deja vu there, but like as I said on a previous podcast, it's like in Victoria, it's like we're stuck in a Christopher Nolan movie, like time's moving forward and backwards. I don't know whether we've reviewed it or not, but it's still a good show. Yellowstone, get around it. Thank you, Andrew, and thanks again for coming, Andrew. I'd also like to say thank you, Chris Berg, as always, my co-host, for leading us through so many tough questions on looking forward.
Thank you, Scott.
And a big thank you to you, the listener, or the viewer, for joining us today. As I mentioned, this is a product of the Institute of Public Affairs. Please do go to ipa.org.au to join or donate. Give us a rating on your podcast platform if you can, or otherwise just get in touch, because we'd love to hear from you as we broadcast into the political void of Victoria and Australia. All feedback is welcome. And we've been having some great messages from listeners lately. But other than that, I'll leave it there. I'll say thanks also to Josh in the control room and say we'll be back with more looking forward next week.